Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to our latest episode of Smarter Lawcast. I'm Carl Rosenberg's partner and health and care co-lead at Hall & Wilcox. I'm delighted to be your host for today's episode. Today we're discussing a really sensitive and complex issue facing aged care providers. And it's on the back of a short article that we put out a couple of weeks ago on how can registered providers manage debt risk in aged care, and in particular how that works under the new Aged Care Act of 2024 and the aged care rules that accompany that Act. The sector is undergoing a fundamental shift with increased reliance on mean-tested co-payments, a government announcement to move away from refundable accommodation deposits or RADs to DAPs, daily payments in the future, and ongoing inflationary and cost of living pressures. So that's the part of the context. So we thought it's timely to have a discussion, and today I've got two experts with me. I'm joined by my co-lead in health and care, Alison Choi Flanagan, a partner in our corporate group, and a partner in our disputes team, David Markham, to talk about some of these issues and some practical ways to reduce risk early and before any arrears start to build, and when it might be time to take things further if that's required. So whether you're listening from the office, out for a walk, or on your commute, thanks for joining us. My initial question, I thought I'd throw it to Alison, just to set the context here, given the new changes with the Aged Care Act that came in from 1 November last year. And principally, we're talking about new residents that join from that date and some of the new fees and what could be some of the pressures. So, Alison, what are the most significant shifts providers need to understand as a result of the new Aged Care Act?
Thanks, Carl. So, as you said, from 1 November 2025, the new Aged Care Act and new aged care rules commenced. And as part of those reforms, the government has introduced means testing, including co-payments for non-clinical care. For approved providers, this means that they have to collect those co-payments from residents, or if applicable, their financial manager or their guarantor.
So what we're saying is that we think there are a couple of issues. One is there's the funding model and the government's move towards potentially favouring DAPs over RADs. And that means that at the end, when someone finishes their time in resident care, that there's not a lump sum that you can offset the debts against. And if that's the case, then you're okay. But if you're under a DAP, daily accommodation payment system, then if the payments stop, then you're on the hook for whatever's occurred. And one of the really sensitive issues is that it's very narrow. And I need you to perhaps talk about this and explain it to us, Alison, but the circumstances under which you could, say, move on a resident from your care if they were failing to pay, I understand that they're very limited.
Currently, under the legislation, residents have the ability to pay a refundable accommodation deposit, which is known as a RAD, or a daily accommodation payment, which is known as a DAP. Residents are entitled to choose one or the other at the moment. The government has announced that they will consider phasing out RADs, but that is not until the long term, that is 2035. The change between RADs and DAPs recently has occurred because some families have decided to pay DAPs instead of RADs, particularly when they consider that their loved one will not stay in residential aged care for very long. This means that there is not the payment of a lump sum, and this may cause issues in terms of debt collection going forward. Under the new Aged Care Act, there are security of tenure arrangements, which are quite similar to the old Act in terms of residential aged care. Under the security of tenure arrangements, there are only a limited number of circumstances pursuant to which residential aged care contract can be terminated. In relation to the non-payment of fees, a registered provider may only ask an individual accessing funded aged care services to leave the residential care home if the resident has not paid any fee or contribution to the provider and the payment is within the individual's control. The problem with that is that quite often the individual does not have the control of payments. For example, they've lost capacity or if they don't have financial means to pay. So that causes all sorts of issues in relation to being able to terminate a residential aged care contract where there's been non-payment. In addition, under the security of tenure arrangements, the registered provider must find alternative accommodation for the resident before they terminate the agreement. So it is quite a difficult process to go through the security of tenure arrangements to terminate an agreement. In addition, there are a number of notification requirements. So going back to basics, prevention is much better than cure. So it's really important for registered providers that they spend time appropriately onboarding residents. For example, making sure that the agreements are appropriately completed and signed, and if the resident does not have capacity, that the appropriate decision maker enters into the agreement.
Thank you, Alison. So avoidance is better than the cure. It's a really sensitive issue. You don't want to go down that path of having to deal with security of tenure rules and everything else, because also commercially and from a PR perspective, it could end up backfiring on you. And I agree. It seems to me there was that sitcom in the 90s. Was it the 90s? The A-Team. And it seems to me that what you want is to have your A-Team doing the onboarding and making sure that they've got everything correct. David, would you agree with that as a general principle? Do you remember the A-Team?
Not sure I remember the A-Team.
Mr. T
but
and the A-Team?
Mr. T, Pity the Fool. I think I've heard of that, but I don't think I've seen it. But yeah, I definitely agree. The best form of debt recovery is really to not allow the debts to accrue in the first place. But if they do accrue, then having all the documentation in place so that you can go back, look at your systems and see what was put in place at the start of the agreement. So Alison touched on most of the main things there. One, so signed agreements, potentially a deed of guarantee from...
So people, you've come across situations where the agreements aren't signed?
Yeah, there can be situations where there's either an agreement that hasn't been signed or there may not be an agreement saved into the system. There might be many years that have passed between when the person came into care, and because of some poor record keeping, there may have been a signed agreement, but it's fallen through the gaps over a period of time, and that might not have been discovered because there were other things put in place at the time. For example, a direct debit or similar, someone's taken responsibility to pay, but if someone stops following that direct debit and you go back to look for the agreement, an unsigned agreement or no agreement will be unhelpful. One of the other things that is useful, if you can obtain it as part of, is understanding where the assets are. For example, the family home. Some providers will take a charge over the family home, which is effectively security over that home, and lodge a caveat, which can provide protection down the track, or a guarantee, usually from a close family member.
With those guarantees, are there issues around the signing and witnessing? I don't want to, but that seems to me with DocuSign and everything else that there are issues with that.
Yeah, there can be, because without trying to get too technical, guarantees are usually put in the form of a deed rather than a standard contract or agreement. And the main reason for that is because deeds are a better document to use when someone is guaranteeing someone else's debt, because they're not necessarily getting a direct benefit for providing that guarantee. And deeds just have more formal requirements, and in a lot of states they still require a witness to witness the execution. And with things like DocuSign being much more common these days, it may Sometimes the documents don't actually provide for a witness, which could be a sort of mistake built into the document, but also DocuSign where people aren't properly witnessing deeds. It may become a problem down the path.
Yeah, I can understand. There'd be such a, I wouldn't say rush, but there'd be such a willingness from the onboarding team to get the person under their care that maybe sometimes these things are missed. Is that a fair enough comment to say?
Yeah, definitely. And there's one thing we haven't really touched on too much is the capacity of the resident. So that's something else that the team is trying to assess at the time. So they've got a lot of things to consider, and often there's time pressure to get the person in and cared for as quickly as possible. But there is some complexity there with quite a few documents to get in place. And then once you put in issues of capacity over the top of that, trying to assess whether there's powers of attorney or guardians, or whether the family haven't really considered capacity issues in the future, that also adds to the complexity at the outset.
Yeah. So with all debts, I've always been told from members of the dispute team that the best thing is to get onto them early and not let them build up. I'm interested in your thoughts on that. And then the other thing here is that this is a particular type of debt recovery because, let's face it, you're going after particular debts under someone's estate. And so maybe just if you can comment on those two issues.
Yes. So a couple of things on the accumulation of the debt is it's best to be avoided, which is not allowing the debt to accrue to a high level where it might come as a surprise to a family member or others. Trying to deal with a debt of $100,000 for anyone is going to be harder than one that's $5,000, $10,000. Making sure that when invoices are not being paid, that's not let to continue to accumulate, and that early engagement with the family or the resident is achieved. And it could be as simple as someone's changed bank accounts or someone else needs to take over the payment, but rather than letting it accrue and leaving it as a problem into the future. And then assuming there is a debt that needs to be dealt with, it's making sure that you are communicating with the right people, whether that's the resident, the family, or a combination, guardians, executive power of attorneys, to make sure that you're dealing with the right person and trying to assess as soon as possible the reason for non-payment and what the potential next steps are.
Yeah, it's a really complex area, and it seems to me that you need a solution that covers the whole country, given there's different rules under different states. And so I think it's, like I said, incredibly complex. And I think I was talking to someone about this, and the issue was whether the resident had given a loan to a family member and whether that should be included in the estate. So there's also the forensic analysis that's involved in working out what's happened with the estate that may occur. I think we've covered off a few things. Maybe we just talk about some key takeaways. Alison, what are the key takeaways? Say 3 key takeaways from you, and then we'll get the 3 key takeaways from David.
As part of the 3 key takeaways, prevention is better than cure. So making sure that you've got the right agreements in place and you train your staff so they know how to ensure that the residence agreements are completed and signed appropriately. Secondly, make sure you've got good records as to who had the authority to enter into the agreements, and if there is an enduring power of attorney or financial manager, keeping a record of that appointment and also how to contact them, because quite often once a resident passes away, it's actually hard to track down how to contact them. Thirdly, be aware of your regulatory requirements. So it's important that you follow the procedure in the legislation, particularly in relation to secure tenure. Another lesson to be learned is that we quite often see residents come in for respite and then they become permanent. And at that point, the appropriate agreement has not been signed.
Excellent. Thanks, Alison. And David?
No, I think one of the first one would probably be some patience once a problem has arisen. There is a lot of complexity here, whether it be dealing with capacity issues or the deceased estate, which can take a long time to get through because an executor may not get probate or other things for months or longer. And then often the main asset is a house, which may be under dispute between family members. A level of patience is going to be required. And then just from a debt recovery perspective, and Alison has touched on this, I think I almost see security of tenure as a separate pathway to debt. I don't really see it as achieving debt recovery. It's something that might occur when a debt has not been paid, but with the cost involved in dealing with those issues, trying to find new care, dealing with family members, once you've got to that stage, it feels like commercially the chances of a sort of net debt recovery are going to be quite minimal, which probably brings us back to the overall message, which is that the initial and ongoing communication to avoid those problems arising is probably the main takeaway.
Thanks, Alison and David. Some great insights, and I'm sure our listeners will take a lot away from today's discussion. Debt risk in aged care is a sensitive issue, but it's also a legal, operational and strategic issue given the new changes to the Aged Care Act of increased funding costs. Thank you again for everyone for tuning in. If you have any questions or want to chat more about anything we've covered, feel free to get in touch. You can find our details at hallandwilcox.com.au or connect with us on LinkedIn. Thank you again.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.